And then we can beat them up with questions.
There you go.
Yeah. All right. Let's see. Give me 1 second. I know you guys already have some questions. Do you have questions that are?
It's about living trust, or?
I can cover estate planning. So if you ask me any question, and if I can't answer it, I'll tell you.
Well, we'll just listen.
Fair enough. Interrupt me. That's fine. Hey, it's not a big deal. So interrupt me whenever y'all have questions. Or. Oh, that's okay.
Perfect. Yeah, you sound great. All right. Cool. That's a brand new mic.
Cool.
So
that's that right there.
Yeah. So, well, you know, but yeah, if you don't mind, hello everyone in the world. Thank you for tuning in. Be More Training. Like always, we are in person, but we want to make it available for everyone else. So, if you don't mind, tell everyone who you are, what you do, how you do it, and all that good jazz.
Morning, everybody. My name is Davis.Puryear. I am an attorney here in Fayetteville. Luckily, Ruben, to his demise, has asked me to come speak today. What I'm going to generally talk about is estate planning. I've been asked to kind of focus on trusts and revocable trusts specifically, but I'm going to try to give my spiel. If anybody has questions, interrupt me, ask them. If I can answer them, I will. If I can't, we'll move on from there. But to give a little bit of background on myself, I am from Fayetteville. I practice in the areas of estate planning, estate probate. I do a lot of our firm's corporate business work, and also do civil litigation, which is most of my litigation is focused in business litigation. I am with the Hutchens Law Firm here in Fayetteville. We're a firm with about 38 attorneys, I think we've got right now. We've got 5 main offices, and I hope y'all are aware, we've got a number of real estate closing offices, satellite offices spread throughout. Our main offices in Fayetteville. We have an office in Charlotte, Wilmington, Columbia, and Myrtle Beach. So we cover both North and South Carolina. We do most all areas, or represent most areas on the civil side of the law. We don't do any criminal work. We do, the firm started as a creditors' rights law firm representing banks and lenders. That's still a very large and prevalent part of our practice, but we've really branched out into civil litigation, bankruptcy, real estate. My area is the corporate business practice and estate planning that we're here to talk about today. But like I said, I'm from Fayetteville. I grew up here, came back here, got a wife, 2 kids, invested in the community, love it here. And it's good to kind of get in front of a group of people like this that's trying to make Fayetteville better. I think the community, I grew up here, so I've seen it come from, even when I was little to what it is now. And I think we still have a lot of room to go, but I'm encouraged about where the city is going and who's coming back and staying here and putting down roots. And it's an encouraging thing to see and talk about. And so thank you all for listening to me today. Like I said, questions, I'm here to answer those. I've got, what I'm going to talk about here today, but if you want to talk about something else, we certainly can. Where I'd like to start is, what happens, to give you some overview, I'm going to talk about what happens if you die without a will. Then I'm going to talk about the traditional 3 main estate planning documents. Those are the 2 types of powers of attorney and a will. Then I would like to move into just this kind of idea, general overview of what a trust is and what benefits come with those, what downsides come with those, and just kind of generally what those are. So like I said, I'm happy to field questions to the extent I can. But first I want to talk about what happens if I die without a will. Everybody has an estate plan. Everybody in the state of North Carolina has an estate plan. It's just the state of North Carolina, if you don't have a will, that decides what that estate plan is. When you die without a will, you die with what's called intestate. That's I-N testate. If you die with a will, you die testate. That distinction is important because the state of North Carolina legislature has come, and every state has this, has come up with a statutory scheme about what happens to your property when you die. So if I were to die tomorrow, I generally kill myself off in these scenarios, rather than clients or other folks. But if I die tomorrow, my estate, everything that I own, I'm married, so I own half of everything I've got that's marital property in North Carolina. Everything I have passes based on the intestate statutes. So one common thing that folks think and are very surprised about if you die intestate, especially if you're married without children. So let's say I'm married, but let's say I don't have kids. If I were to walk outside and get hit by a bus today, the first portion of my estate goes to my spouse. But if I don't have a will and I don't have kids, my parents can very well inherit a portion of half of everything I own. That surprises a lot of people. Everybody just assumes everything goes to I don't need a will, everything goes to my spouse, and that's not necessarily true. That's the same as if you do have kids. If you die, a large portion goes to your spouse, but then your kids will also inherit a portion. Generally, on the personal property of your estate, your spouse, there's a lot of different rules, ways that the spouse can get more. But generally speaking, the spouse can get the first $60,000 or $100,000 out of the estate, and then the rest is split between either the spouse and parents or spouse and kids. So that can be a really important thing, especially if, not everybody in the family gets along. Maybe you don't get along with your in-laws. Maybe you don't get along with your children, which certainly can be the case. So I find that when people walk into my office after somebody's passed away that doesn't have an estate plan, it sometimes can be a very surprising conversation. So I certainly suggest that you have a will. So to prevent all this, so you can decide who gets what and who's in charge. That brings me to probate. You all probably understand probate to the extent that it is a pain in the neck. And I have people that come to me all the time that say, probate's a pain in the neck. It delays the real estate closings. It delays who gets what. Going down to the courthouse, filing these inventories, filing these accountings is just difficult. I don't understand it. I've got to hire an attorney to do this, who I'm going to pay a couple $1,000s to do it. So if you die intestate without a will, your assets go through probate. Generally speaking, what probate is, if you die with a will, you still have to go through probate unless you've done some extra planning, which includes like a trust or other planning. But generally speaking, what probate is, it's when the clerk of court oversees the distribution of somebody's assets after they die. So if you've got a will, or if you don't have a will, you've got your listed beneficiaries here. The executor or the administrator lists, these are all of Davis's assets that he had on the time of his death. You file an inventory saying this is what he's got. You file a notice to creditors where any creditors of the decedent can come and file a claim and get paid. Once you pay the creditors, then the equity in the estate gets distributed to whoever the beneficiaries are, whether it's the intestate beneficiaries or the testate beneficiaries through a will. So it can be a cumbersome process. It delays the beneficiaries getting assets. People get frustrated with it. It can be frustrating. I do it for a living, and it is frustrating. Sometimes the clerk, I see it one way. The clerk of court maybe wants me to file that accounting or distribute this asset in a different way. So it can really slow down the process. It can create problems. It can create hard feelings between kids, especially or beneficiaries, especially if somebody is the executor doing all the work for other beneficiaries who are sitting back and just going to get the benefit of the estate and the asset.
Someone said, you mentioned in-laws, and my wife gasped, we'll be seeing you soon.
Well, fair enough. Come see me. But yes, that certainly can happen. That is intestate in a nutshell. That's probate in a nutshell.
Any questions?
Any questions on that?
I'm on the right of
Okay,
Okay.
sounds good. So now I'm going to jump into the traditional estate planning documents. Before we went live and before a lot of folks stepped in, we were talking a little bit about, when you were kids, you just generally heard mom and dad or grandma and grandpa having a will and powers of attorneys, and that was it. You didn't hear a lot about trust. So the traditional 3 estate planning documents are the durable power of attorney, the healthcare power of attorney, and a will. I'm going to hit them in that order. So your durable power of attorney is the document that's effective during your lifetime. It is where you name somebody else to name financial and make property decisions for you, manage your estate assets during your lifetime if something happens to you.
So is estate planning your trust and estate planning kind of interchangeable?
Yes, so the estate planning is just and I may be using estate for different reasons, and that may cause confusion, but estate planning is just the general idea of doing planning for something to happen to you, whether it's you become incompetent, you need assistance while you're living, or even what happens to your assets and your property after you die. I also use the word estate as in the assets that you own, whether prior to or after death. So your estate is just this general idea of that's all your assets. And then the planning piece is what happens to those or who manages those. So this durable power of attorney, it's durable because it is effective even after you become incapacitated. The purpose of this document is if I walked outside today and get hit by a bus again, I have a traumatic brain injury. I can't manage my own assets. I can't sign on my own behalf. Maybe my wife can do some things like a joint bank account, but let's say I own a business, or let's say I have a vehicle titled solely in my name or accounts in my name, then she can use that document to take care of me and take care of my family, just as if I was signing the name. Y'all are all familiar with the power of attorney. So just as if I was signing my name on the dotted line as well. That prevents or tries to prevent you having to go through a guardianship proceeding. It's really important. I see it. Yes, it's very important even for young folks to have if something happens to you, but it's really important, especially with elderly folks where, mom and dad, grandma and grandpa can't necessarily go to the bank anymore. They may be bedridden, even if they're mentally competent. So this power of attorney can be drafted one of 2 ways. It can be effective immediately. So once it's signed, the agent who you're naming to be your power of attorney has the authority to enter the document as soon as you sign it. It can usually you draft them that way for folks that know they will need it to be used soon, or if they're elderly and won't help now. The alternative, I suggest this for younger folks, is if it can spring into effect. So even though you sign it today, your agents can't go sign on your behalf until 1 of 2 things happen. One, you give them written authorization that this power of attorney is now effective. You staple it or attach it to the back of it, and they can take it wherever they want to go to and use those powers. Or it becomes effective upon your incapacity. So, bus example, I get a TBI, I can't manage my own assets, then my wife could step in and manage my assets for my benefit during my lifetime, and even hers. And that can also be effective through temporary incapacity as well. The next traditional estate planning document is a healthcare power of attorney. So the durable power of attorney was financial. A healthcare power of attorney is for healthcare. I don't like defining a word with the term of the word, but that's exactly what it is. It's where you name somebody else to make medical decisions for you if you are incapacitated. Nobody can make medical decisions for you if you can make them yourself, but you have to be found incapacitated. It can be temporarily if you're in a temporary coma, or permanent, let's say dementia or things of that nature. I like to draft my healthcare powers of attorney to also include what's called a living will. where you make the decision now about what you want to happen if you got to be put on life support. Some people draft them separately. You can have a healthcare power of attorney and a living will. I think that's fine. My stance on it is put all the healthcare decisions in one document. That way, your agents don't have to say, which one do I bring to the doctor? I lost one, here's the other. It just makes things in life easy, makes things in life easier for your agents. And it can be drafted to name a different agent for each document if that's really what you want to do. But living will is where you make the decision now. If you want to be put on life support, there's scenarios essentially only you get to make that decision unless you're incapacitated, but you can make the decision now about if you want your agent to decide if you want to be put on or taken off life support. If there's no hope of you ever recovering for what you're being put on life support for, you can say, but make a directive that you don't want to receive any life support if there's no hope. It's essentially medically certain you're never going to recover. Or you can say, I want as much life support as medically reasonable to give to me for as long as you can give it to me. So the way I draft it is, it's always a uplifting conversation to have with folks. But I say that sarcastically because it's not, but it is serious, and it is really important conversation to have. You can take the burden off family members on agents by making those decisions now and having those conversations. So I certainly suggest that it be done, and I think it's an imperative part of your estate plan.
Curious, what do you guys like? I know we're not going to stay on this too long, but what would you guys say on those three? Just
What do you want to say?
huh?
I would say, as far as the power of attorneys in the health, especially healthcare, I have an adult child where it came into play. And unless the nurses are nice and want to tell you the information, they're not going to tell you anything. So you need to have it.
Sure.
So you can go ahead and get it on all your kids, like you would recommend your kids and your spouse usually, or parent, like how do you?
They've got to be of the age majority. They have to be adults. So they have to be at least 18 to sign a power of attorney. Otherwise, the guardian can make these decisions. So I actually get more recently, for some reason, I've gotten more college students. Kid goes off to college, they're 18. Mom and dad, they're 18. Mom and dad can't just call the school, can't call the hospital if something goes wrong and says, hey, give me this information. I'm going to make this decision on treatment. Yeah, they're in charge if the minor's incapacitated because they're the next of kin. But you got hoops and things to go through. And that way, if you walk in with power of attorney or even a HIPAA waiver where the minor has waived HIPAA, then you can go and make those decisions. So my one suggestion, if you want to bring in a young adult, college kid, just young minor, try to have these conversations before and talk through it with them. I can talk through these things with them as much as I can in a conference room, but every time I sit the 18, 19-year-old down and have this conversation, their eyes just go this big. And, so that would just be my practical suggestion for that, is try to have the conversation. It's not a fun conversation, but it has certainly been something I know that makes people rest easier, especially with those young kids, young adults.
So if you don't have something in place, it would be a next of kin situation if
That's right. That's right.
Have anything in place.
Can you repeat the question so Mike, if that's okay?
Yes. So the question posed was, thank you.
Yep.
Essentially, what happens if you don't have a healthcare power of attorney? And the answer to that is it's your next of kin that makes the decision. So that may be fine, and you're okay with that, but they still have to prove they're next of kin and try to contact the other kin. So, spouses, it's easier. But let's say you are a parent, your spouse is predeceased you, you've got 4 kids. Let's say I really like 2 of my kids, but I'm estranged from the other 2. Happens all the time, unfortunately. And so it's really important because you've got a deadlock between your 4 children you don't get along, 2 of which you don't trust and get along with, or let's say you only trust and get along with 1 of them. So that becomes very important as well as, at least you've made these decisions now, especially if you have in-laws. Understandably, if you've named your spouse has the right to make these decisions. But, if you can show in-laws, other family members on a piece of paper, siblings, sisters, sister-in-laws, brother-in-laws, this is what they've decided. It can ease feelings and understanding rather than putting the burden and the fight on those that are still living, or still maybe not living, but those that are still able to communicate and make decisions. So I think it's an imperative part of estate planning, the healthcare power of attorney. Durable power of attorney too in the will, but healthcare power of attorney can certainly ease some beneficiaries' thoughts and things like that. So the third traditional document is a will. Everybody knows, generally speaking, what a will is. This is where I want my property to go after I die. In a will, there are specific bequests, specific gifts, and residuary gifts. So specific is, I want the diploma to go to little Johnny, and I want the china cabinet to go to Susie. Those are things specific is. The residuary gift is, I want everything else that hasn't been given away specifically to this person or this group of people. Traditionally, you see with married couples, I want everything to go to the spouse, and if the spouse predeceases me, I want everything to be split evenly or disproportionately between the kids. Now, you can also include burial directions and other specific provisions in that will. Will is subject to probate. Any assets that pass through will still goes through that same probate process. One of the things about a will is, subject to probate, the beneficiaries get these assets immediately. So if you say you've got a 19-year-old, let's say your estate is $1 million, that 18-year-old's going to inherit $1 million subject to probate and can do what they want to. You name your executor, that's who's in charge of managing your probate estate, managing the assets, and distributing them to the beneficiaries. One part, and this is a different type of trust, and the next thing I'm going to talk about are some, just kind of a general overview of what a trust is. But I'd like to cover this trust here now to not attempt to not confuse everybody. There's something called a testamentary trust. And what that trust means, testamentary means created at death. So you can have a testamentary trust as part of your will that doesn't come to fruition until it is funded through the will at your death. And funding means assets put into that trust. Now, testamentary trusts are good trust. The folks I usually suggest a testamentary trust for are the young couple or young family that has minors, that they've got really young kids. You don't have a lot of assets. Your estate's not going to be large, but you want to leave your estate to your minor beneficiaries, where you can name and create this trust under your will. And the way I like to draft testamentary trust is you just put an age limit on when those minors are able to receive the benefit of the estate. 21, 25 is what I generally use. That way, your trustee, who you name in the will, can manage those assets during the beneficiary's lifetime until they turn 21 and 25, and then they get that lump sum. This at least prevents that 18, 19-year-old from getting all that money at one time. You picked an age, whatever you want it to be. I don't suggest that age is way off in the future because it makes administration difficult. But that is a type of trust. It was generally preferred before these next type of trusts I'm going to talk about were created. If you want to get into any more detailed trust provisions than just what I've explained, you need these next type of trusts, because you're going to pay the same for them and you're not going to get the benefit of them. So I like to keep my testamentary trust simple. They're, like I said, they're for those young folks or for those folks that want to leave something to a minor that may not have the assets that would make a revocable trust make sense for. I mean, revocable trust or other trusts are more cost up front. a lot of times less cost on the back end. So essentially the prohibition or the reason why people don't get them is the cost of setting them up. So that's just a quick overview. So if you hear testamentary trust, that's what that is. I'm gonna move into trust now. So the most popular type of trust that I draft and plan is kind of the basic kind of trust. It's what's called a revocable trust. It's also called, the IRS calls them grantor trusts. The IRS makes their own rules, so they do what they want to. So they have named these grantor trusts. They've also been called living trusts. They can be called revocable living trusts. I mean, you name it. What that means is, generally speaking, there are two types of trust: revocable trust and irrevocable trusts. It's defined in its name. A revocable trust can be changed, revoked, amended. You can revoke it, portions of it. You can change beneficiaries in it. You can put assets into and pull assets out of them. That's generally where you start your estate planning and trust planning. There are also irrevocable trusts. There's a bunch of different types of irrevocable trusts. I'm not going to get into those. That's a whole nother conversation for another day. Essentially, the big benefit of irrevocable trusts are tax planning. So you go put these assets, they're no longer owned by you, they're no longer taxed by you, so you can give them away during a period in which there's a large estate tax threshold, or even you can give them away for the benefit of charities and get a tax write-off at death. So one of the big types of irrevocable trusts are called share remainder trusts, where you take a big asset that's income producing, you put it in this irrevocable trust. It's owned by the trust, it's managed by the trust, and you get the benefit of the income, or maybe, and sometimes some beneficiaries get the benefit of the income from the trust during your lifetime, and then at death, the remainder, charitable remainder trust, goes to some type of charity, and you get a tax deduction at death to pull those amounts that are over the estate tax exclusions. You get a deduction. So you get to choose. You're not keeping the money, you're not keeping the asset, but you get to choose where that asset goes to, and it goes to charity rather than, you know, paying taxes to the government. So that's a big benefit to some folks. But where I want to head towards is the revocable trust. So this is a trust you create now. You can fund it now, which means put assets in it now. And you create it now, you set out what the terms are at death as part of your estate plan. The concept is, the broad concept is the same as a will. You choose where your assets go after you die. Like I said, it's revocable. You can change it. You can add assets to it, pull assets out of it at any time. But a revocable trust is better than a will for a couple reasons. One of the reasons it's better than a will is it avoids the probate process. So any asset you go ahead and title in the name of the trust, the classic example is your home. So let's say I own my home, but right now when I do this planning, I convey my home to my revocable trust. Now, I'm still the grantor, that's the creator of the trust. I'm still the original trustee, so I'm in charge of managing the trust for the beneficiaries. And I'm the original beneficiary until my death. So I'm not changing anything other than the title that's listed on the deed. It'll be the davis.puryear revocable trust. And so I'm still in charge, but at my death, that asset isn't owned by me anymore. It's owned by this trust. And so it's distributed based on the terms of the trust. So that's not a probate asset. So it avoids the whole probate process. The beneficiaries can get access to these assets immediately. That's subject to the terms of the trust.
Does that make sense to everybody?
Is there an issue with the mortgage company and then transfer?
No, there's not. The Garmin-St. Germain Act is what I think that it was addressed in. It says the due on sale clause in your deed of trust is not triggered, cannot be invoked by transferring your property to a revocable living trust. So you don't have the same issue that you folks run into with transferring rental property to LLCs that can trigger the due on sale clause. That does not happen with a revocable living trust. As long as it's a grantor trust like this, as long as it's a revocable trust owned by you.
We do have one question, real quick. How term life insurance works with wills and trusts?
Well, that does lead me into the next thing I was going to bring up, so that's helpful. I mean, your term life insurance, it's life insurance policy that pays to beneficiaries. If you just have a will, you're not going to do anything different with that life insurance policy. You're going to make the beneficiary whoever you want those beneficiaries to be. With a trust, you can actually name the trust as the beneficiary of that policy. You can do the same thing with any payable on death accounts or other assets. So investment accounts, life insurance policies, retirement accounts. You want to be a little careful with that just based on the required minimum distributions that your beneficiary is going to have to take, but that can be allocated for in the trust. So what that leads me to is what you want to do with this trust is you want all your assets. This is a big pot that we've created at death. So what we want to do is we want to move all your assets at death somehow into this trust to be distributed based on the terms of the trust. That can either be done before death, change in beneficiary designations as part of or payable on death designations. So immediately at death, those pay into the trust. If they contractually, so automatically pay into the trust at death or go into the trust before death, all those assets avoid probate. So you've avoided probate. The goal is to avoid probate all the way or with a majority of your assets. One example of an asset that you're not going to title in the name of the trust are vehicles. The reason for that is you're going to pay corporate insurance policies on those personal vehicles because it's owned by an entity, which is a trust. So what I kind of tongue-in-cheekly tell my clients is the goal is for you to live so long, your kids get rid of your cars, or you're not allowed to drive anymore. Or if your two vehicles are the only assets that you have to probate, it's a pretty good day. So that's just a reason why that's just an example of one of those assets. Another benefit that ties into avoiding probate is that this revocable trust is private. It's not recorded. It's not filed in the clerk's office. It is private. So that is important, especially if you've got minors that are going to inherit. You know, right now, the clerk's office, all filings are done by paper. So if I wanted to know what, you know, Jimmy inherited, I could walk down there, pull his estate file and look and see exactly what he inherited if it all passes through probate. Now, do I think people are really doing that? Probably not, but they can. But North Carolina right now is moving to a electronic filing system. So all records, well, it's been delayed another couple months. It was supposed to, the test pilot counties were supposed to go into place this month, but it got delayed a couple months because they're still working out the kinks. But presumably, when this is effective, anybody can go online and look at any estate file and see these estate filings. It's public record. I mean, it is public record, so anybody can go online. Presumably, they have to create a login, but I don't see how that's going to be real difficult. And they can go in and see what everybody's inherited. So privacy was always kind of it's probably not a big deal for you, but it's very important to some people. But now in the coming years, if all this is going to be accessible online, I know that's going to be a big deal. It would be a big concern of mine. I don't want, you know, I've got a 3-year-old and a 6-month-old. So if I died next week or died in the next 5 years, I don't want anybody knowing that my 12-year-old just inherited, you know, what I'm going to leave them.
And what exactly are they doing during probate? I mean, I kind of have a general understanding of pain, but like, what are they doing? Who are they reaching out to? Like, try to figure out who's getting what? What are they?
The question posed was essentially, what does the executor do? What does the clerk's office do in probate? And you gather up the assets and you distribute them. But when I'm talking about privacy, you file an inventory 90 days after the estate is open. So quite literally, when I die, when I die tomorrow, 90 days after somebody opens my estate, they filed an inventory, which is a concrete list of every asset I owned at the time of my death. So my entire net worth is on 2 pages of paper. Then you pay creditors and you have to file accounting. So you have to allocate where every dollar of that inventory goes and who it goes to. So on the final accounting or intermediate accountings, annual accountings, they would list beneficiaries and how much they got, when they got it, and how much they got. So let's say I died, my estate's $1 million. That'd be nice. But let's say my 2 kids get half of it. My son would be listed there as getting $500,000, and my daughter would be listed there as getting $500,000. And it's not really something that I want sitting out there, I don't think. Another benefit of trust, and I really haven't gotten to the meat of it, is you can put future restrictions on beneficiaries. So you've all heard about trust funds, trust fund babies, your friends or acquaintances that mom and dad set up a trust fund for them and they don't work hard, or, they just get the benefit of that monthly payment. It's exactly what this is, usually without the bad connotation. But you make specific requests. I want this thing to go to this person, or this amount of money to go to these people. And then you have residual requests. I want everything else to be held in trust or managed for the benefit of the beneficiaries. So you can put future restrictions on these beneficiaries. So let's say you have adult children or you have minors. In North Carolina, a minor can inherit more than a very small amount of money that's not left in trust and managed for them until they turn 18. So with this trust, you can decide where it goes and on what terms the beneficiaries get them. So you can say you get the money in stages during your lifetime. With young kids, if you don't really know how they're going to turn out, I like to use milestones. So they get 1/3 of the trust at 21, usually when they're graduating college or been working for a while. Get the next third somewhere between 25 and 30, usually when they're talking about getting married, maybe settling down, and maybe the last third at 35. At that point, we may have been talking about having kids or those things. You can be as restrictive as you want to. So you could put substance abuse provisions in there that, they have to prove that they're clean before they get distributions. You can be, as long as it's not unconscionable, you can put many types of future restrictions on these folks. You hear the old trust that, if the daughter is not married by the time she turns 25, she's disinherited. I mean, those are some of the old case law provisions you see. Or if the son's not working in or daughter's not working by this age, they are disinherited. I mean, those are some of the very stringent restrictions that I've seen. But I don't suggest you be too restrictive unless there's good reason to be. But that is the purpose of that trust. You can allocate for them. You can decide when they get it as well. Another big reason during your lifetime for having a revocable trust is if something happens to me and I've got this revocable trust, the assets title in the trust will be managed by my successor trustee. So that's not my power of attorney. That's not a guardian. It's not susceptible to going through a guardianship proceeding. The trustee can manage those benefits for me during my lifetime if I become incapacitated and prior to death. And I'll just hit on this quickly. You can create a joint trust where usually you see husband and wife step in and creating a joint trust where they just take all their assets together and put them in a trust to be managed for their lifetimes. They're both the trustees, they're both the beneficiaries. You can also have separate trusts. The reason each have separate revocable trusts. One of the reasons and benefits to that is one, maybe if you have a blended family and you have kept your assets separate, kids of first and second marriages, you want to ensure that the surviving spouse doesn't write out your kids, that your biological kids that aren't biological to your spouse, is a concern of some folks. Another reason to have a separate revocable trust is to hold a business interest. Let's say you've got an LLC and you've got partners, and if you don't have an operating agreement in your LLC with partners, then you need one.
Any questions so far? You guys are here?
Yeah, I have a question.
Sure.
As far as like assets go, if you have a trust in place, are you having to like continue to come back to you to add them in, or is it more so like a blanket, like any properties that are owned?
The question was, once the trust is formed, how do you get property into the trust? Do you have to keep going back to the attorney that drafted it to put it in there? And the answer is no, as long as you can do it yourself. And what I'd like to draft for my clients is what I call a trust funding memo. Got like a 4-page summary of the big assets or what assets I think are common. And I put instructions about how to get those in the trust. So like real estate, you prepare a deed, commit it to the trust. Life insurance designations, you change the beneficiary. So it would just be you contact. I don't do that generally for my clients because there's no reason for you to really pay me to call a life insurance company. They're going to have to get you to consent to do it anyway, and you're going to have to sign the beneficiary form. So you just contact them. Same with in retirement accounts, investment accounts. I help people fund these trusts all the time, but generally speaking, a lot of the legwork will be done by the creator of the trust, the client, just because they're the ones that have to go sign on the paper. If that makes sense. Sure.
So, I guess in your experience, is it easier to purchase within the trust or outside of the trust and then convey it to the trust? Based off of the trust income that it's producing.
During lifetime, I don't see that many people purchasing real estate in the name of the trust. Now, I'm usually doing the planning, so I'm not like you guys that are doing the real estate closings. Based on the rule that the due on sale clause can't be effectuated, it's not as important like an LLC is or a corporation is. So a lot of times I see people purchase it in their name, but it just depends on the closing attorney and the mortgage company. A lot of times if you've got a larger mortgage company, they understand if you get a good loan officer or mortgage broker, then they can understand the concept. But if you necessarily don't, then maybe the right thing to do is buy it individually and then just go ahead and convey it. It's just.
Have you seen anyone? No. Okay.
We never have anybody.
Purchase with a trust?
Yeah.
Was it? Was it?
Where you normally see that maybe with like irrevocable trust, when the person has died and the revocable trust becomes irrevocable, then the trustee can buy property or sell it. That's where I see it the most, where I get a call from our real estate department, our office, say, hey, what do we do with this? Or here's a trust, what do we need? That's where I see that more commonly.
When they bought in the trust, was it cash or was it financed?
Oh, that's probably why.
Yeah.
I just have a lot of people like, I want to add my daughter to deed and my sister, they more so like want to add all these people to the deed.
Yeah.
Is what we usually see, but I haven't had anybody purchase with a trust. No.
Okay. That's a good question.
But I just feel like people just don't know about it. Like, it's still.
That's why we I bring you up in front of it.
Yeah.
That's right.
Yeah, the one we have under contract is with our name, but it's going to be, that's where we reach out to you after it's all closed and done, and just rolling it into the trust afterwards. I never thought about actually purchasing it with the trust.
Well, if it's producing income.
Yeah, totally. So I'm new to this too. We just set
Well,
it up.
it really just kind of comes down to what's going to be more paperwork and what's going to be more expensive is kind of what I tell folks. You're going to have to give the closing attorney, a certification of trust, proving who the trust is. Personally, I don't think there's much of a difference, but it depends who you've got doing it, I guess.
Okay.
I think if you have enough cash, it's simple, but if you're trying to finance, it's a little bit.
Yeah.
So my guy was taking cash from his trust and then purchasing.
Oh.
That's what made it super simple. So you had the cash in the trust. I mean, was the deed made out to him? Like,
It's made out to the trust.
but the whole purchase agreement was in his name, it just was deeded to the trust?
No, the purchase agreement was in the trust.
Sure.
Cool. You got options is what I'm hearing. Good.
What are the tax advantages or disadvantages to the trust?
So with a revocable trust, sorry, thank you. The question was, what are the tax advantages or ramifications of having a revocable trust or having a trust? Disclaimer, I'm not a CPA, so I know enough about taxes and accounting and all that to make myself pretty dangerous. So disclaimer, ask your CPA, don't rely on what I'm telling you. A revocable trust during your lifetime, there's no tax difference. It's treated like a single member LLC. Remember earlier when I kind of tongue in cheek said the IRS makes its own rules? The IRS really does make its own rules. It's called the tax code. So a single member LLC is a disregarded entity. Same with a revocable trust. The IRS pretends that they don't exist. So you're still going to pay taxes on the profits and losses and the income of the trust on your individual return. So there may be a couple more documents that are filed by your CPA when you file your return, but it's not going to change anything there. Now, if the trust is irrevocable, so after your death, one of the considerations that you want to make is if you put future restrictions and you hold property in trust for your beneficiaries, the income on those assets is going to be taxed at the trust tax rate. So I don't know what it is off the top of my head, but generally speaking, it is more than everybody's personal income tax bracket. So paying that trust tax makes a lot of sense if you got minors, you got benefits, it's a give and take. I'm afraid my 25-year-old kid is going to go buy a Lamborghini and a $5 million house and blow it all in the bars and clubs. It's worth paying the tax, the little bit of more tax on that income. So it's kind of a give and take. But generally speaking, with a revocable trust, there's no tax difference. Once a trust becomes irrevocable, income's taxed in the trust rate unless that income is distributed automatically annually to the beneficiary. So there would be no income to the trust.
Could you put the income in a whole life insurance policy or something like that?
That's above my it's above my pay grade. I don't know that.
The trust can purchase policies
Right.
from beneficiaries.
And then you could pull money from the policy, and the government can't tax the loan.
But each time a person dies, it funds the trust as well.
And that, I was wondering about that, Rockefellers do that.
They figured it out. If there's a family that's figured it out.
So your life insurance policy is not taxable. So if you put it into a trust, does it then become taxable?
Income is taxable.
Okay.
So just by leaving assets to the trust, it's not taxable unless you're above the estate tax threshold, which I'll go into right now is $11 million for individuals, $22 million for a marital unit. So husband and wife, wife and wife, whatever. That's $22 million for a marital unit. That law was passed in 2020, maybe before that. I can't remember. It was passed during Trump's his first term. It's higher than it's ever been in the past. That law, it automatically sunsets in 2026, and that $22 million, I'm going to use $22 million because it's a bigger number. That's the couple. It drops down to, I think the amortization on it or the calculation will be $12 million for a couple. So if you have assets in excess of $22 million or after 2026, $12 million, assets over that threshold are going to be taxed at the trust rate, the estate tax rate, which is like 45%, something stupid. So don't know what's going to happen between now and 2026. I'm not being political here. If you would have asked Bernie Sanders and during the first election, it was going to be like $300,000 Biden was running on somewhere between $3 and $6 million. Trump was running on his current exclusions of $22 million. One thing you want to think about is you've got a lot of rich Republicans, you've got a lot of rich Democrats. Do I personally think, and this is a disclaimer, this is just Davis talking, do I think it's going to go back down to $1 million? No. Do I think it's going to stay at $22 million? Probably not. 12, 16, somewhere in there is probably where it's going to be. I don't know that for certain. It's just my suggestion. So if it doesn't, Congress can certainly, especially after our election in November, depending on what happens and who's going to control the House and the Senate, whichever way it goes, they certainly may change this before the law sunsets in 2026. So just something to consider.
Stay under that threshold?
No tax. No tax. There is no North Carolina estate tax. Just federal.
I got a question real quick. It says, to be clear, you can put an entity into a trust, essentially transferring ownership of the business with intent for the trustee to pick up where you left off and avoiding sale of dissolution. I said that right. Even if they are not a current member.
That is a perfect question because that is right next in my notes to talk about. So, yes, and you can own the membership interest of an entity, corporation, LLC, in a revocable trust. That's a great estate planning tool. Where you have to be careful about is if you have other partners and if a transfer of your ownership interest in that entity will trigger your buy-sell provision in your operating agreement or shareholders agreement or whatever you got. Need those documents. So one way, generally speaking, let's say I own an LLC and I've got a friend, he and I own it 50-50. Got an operating agreement that says any transfer triggers a buy-sell, which you should have. I'd have to get his consent to transfer my ownership interest into a trust. Let's say I like his spouse and he likes my spouse and we're both comfortable with our spouses owning and managing that ownership interest. Great. I can put it in my joint trust that I've got with my wife. Let's say I don't like his spouse and he doesn't like my wife. One way to get around that with consent of the other side is to put that LLC ownership interest in a separate revocable trust just owned by me to be managed by me. Certainly something you can do that allows the trustee, whoever that is, and generally speaking, one practice point is you want to know who the trustee is going to be of that trust in the future after the death of the original partner. So you know who's making the decisions, and they can manage that LLC interest, even if it's a single member LLC, they can manage that LLC interest for the benefit of the beneficiaries. Let's say it's a piece of, let's say I own the LLC that owns Harris Teeter right next door. Be a great thing to put into a trust where the trustee can manage that LLC. You still get the liability protection from the LLC, and all the income pays into this trust that's paid to my beneficiaries. Let's say my two kids, trustee manages that piece of commercial property for them and then distributes their distributions to them as the trustee sees fit and can manage that company from them. That way, I've decided who's in charge when I die of that LLC. It also prevents one or both of them from my kids or the beneficiaries from stepping in and trying to dissolve it. You know, it can also prevent deadlock there where you've got the trustee or the manager you've named in that LLC, and this is getting down rabbit holes, but it allows you to choose who's in charge, essentially. So I think it's a great tool. I think one place that you've got to be careful with that is professional entities, lawyers, doctors, CPAs, anybody that, you know, you've got a professional corporation or a PLLC the governing board may not allow that. Like a law firm, a trust can't own my ownership interest. The state bar won't allow that because the owner wouldn't be a lawyer. So that's just something to take into consideration. I think that's kind of, I've talked for a while. I think that's kind of what I had to cover. I am more than happy to field other questions though.
Yeah, I mean, obviously a lot of this is very unique to the person or to the couple. And so it goes deep into what, I guess some of the things that you want to accomplish. He's got the answers for them, but again, very specific. So if they want to set up an appointment or something like that in the future, until then, what questions do you guys that maybe chewing on? I saw you write down a few things.
I don't have that many, but
Go.
so I do have a very unorthodox familial situation, so I think we can sit down and talk about that.
Yeah.
Sure.
Okay, so for probate, I find myself in a lot of probate situations with like buying investment properties or
Sure.
just being a real estate agent. The order of events, like once you initiate probate, once you apply for probate, it seems like certain things have to happen in order to make that sale. So, like, what does that look like?
Your question is for somebody to sell a piece of real estate, what has to happen first in the estate to allow that sale to move forward? Is that right? The first question is, if the will directs that the property has to be sold by the executor, that's a whole different story. What I'm going to talk about here is two people just inherited the property into the will. They can do what they want to with it, right? You got to open the estate. You have to run your forced notice to creditors. What the title insurance companies will generally require is that notice run for 2 weeks. I think it's got to run for 2 consecutive weeks before they will, the title insurance company will insure title. That's your restriction. Now, the title insurance company will require the executor or administrator and the beneficiaries to sign an open estate indemnity agreement. So what that is, generally speaking, is, let's say I've got an open estate. My sister and I are the beneficiaries. I'm the sole executor. We want to get rid of mom and dad's house quickly. So I've opened the estate. I filed my inventory. I've run my notice to creditors for the first 2 weeks. We're going to close next week. Title insurance company says that's fine. Now, the title insurance company will require us to sign an open estate indemnity agreement. What that means is, if the estate has the right to go claw back real estate that passes to the beneficiaries to satisfy claims in the estate, if there are not enough assets to pay those claims. So what that indemnity agreement says is the estate and the beneficiaries are waiving their right to go after and claw back that piece of real estate, and will indemnify the title insurance, and essentially will pay the claims. In the event that there are not enough assets, they'll pay it from either their own pocket, or they will pay it from the proceeds from the sale of the real estate. What I like to tell folks that want to do something like that is, if you close, don't get rid of the money from the sale unless you are just independently wealthy. Don't get rid of the proceeds from that sale until that notice to creditors ends, and you can confirm that you've got a liquid estate to pay all the claims.
Who drafts the indemnity letter and who signs off on it?
Your closing attorney should likely be drafting that agreement. But if they don't, usually I've drafted them for closing attorneys that are unwilling to draft them or don't draft them. It's a 2-page form. I think I'm 98% sure it's a real estate commission form where it originated from.
Okay. And then is the clerk of court signing off on that, or is
Nope.
it just?
It's just through the closing. The people that sign it are the executor, administrator, and the beneficiaries.
Okay. So the order of events, whether it's testate, intestate, is you have to get that, you have to get the open estate, apply for probate. You have to notice your creditors. Do you still have to do the newspaper thing?
That is the notice to creditors.
Okay.
So notice to creditors, you have to send specific notice to known creditors. So if I know the decedent had a $50,000 Amex bill, we have to send them notice. And then you publish in the newspaper for 4 consecutive weeks. And that period is open for 3 months where somebody can come and file a claim in the estate and say, the deceased person owed me X amount of dollars. That is the claims process.
Okay. And then once that happens, you have to inventory the estate, and then the report signs off. If there's no inventory, after they sign off on, you can sell it or not.
The clerk of court has no input in the sale of real estate. This is confusing because it doesn't make sense, but it's the rule in North Carolina. Real estate, unless it's willed to the executor, willed to the estate, passes outside of the estate. So at death, the beneficiaries own that real estate immediately, and it is only an asset of the estate subject to being pulled back in and sold to satisfy claims. So unless there's not enough claims, the clerk really doesn't have any input on the sale of real estate.
So I'll say this: it is 10:31, which is interesting. 10:31. 10:31. So now I'm kind of on y'all's time, right? So thank you so much for obviously showing up. If you don't mind, if you got to go, totally nothing I can do about that. You guys head out. But is there any ahas or something you learned here today that you didn't necessarily know before? Something that rang.
Regarding, say, Germain Act. I mean, I was familiar with the concept. I just didn't have a name for it.
I am 98% sure it's in the Garment St. Germain Act, but I could be wrong, but I'm pretty sure that's where it is.
Wrote it down. What else? A lot of information. Give me one more.
I've got one. My one piece of caution is don't try to draft your own will. Just don't. I see internet wills all the time. You don't have to come to me, but go to somebody to get a will. If it's just a basic will, it is worth paying for it now than the mistakes. And I know I don't try to, broker real estate deals. I don't try to do my own plumbing. Just go to somebody and get a will drafted. It is worth paying to have that done, just because there's so many little niche rules that you can wreak havoc on your beneficiaries if you don't. That is my one little tidbit. Don't trust them. They he asked, what about holographic wills? Holographic wills are wills drafted by the decedent, and they have to solely be in the handwriting of the deceased. I've probated holographic wills. I have seen one or two that were actually pretty good, but they leave everything out that you need in there. That's where mistakes happen. There's just so many little niche rules that you're going to violate.
I've never even heard of that. I thought you were just playing.
No, it's a real thing. They are valid in North Carolina, but don't rely on it if you can.
Yeah. Well, where can everybody who's watching online find you? Because we're passing around a card now.
Sure. Well, like I said, I'm with Hutchens Law Firm. We've got an office here on Ramsey Street. Our website is hutchenslawfirm.com. You can find us there. If you've got questions, you're welcome to reach out to me as well. My email address is davis.puryear, PURYEAR at hutchenslawfirm.com. So more than happy to help you. Thank you all for listening to me today. And call me if you have questions or need anything from us.
Adios. Adios.